Welcome to Antidemocratic, a conversation with David Daley. I'm Bruce Spiva, Senior Vice President at Campaign Legal Center. CLC is a national organization working to advance democracy through law at the federal, state, and local levels. We fight for every American's right to participate in the democratic process and believe our democracy should be transparent, accountable, and inclusive. In 1965, voting rights advocates secured the passage of the Voting Rights Act. The law sought to remove some discriminatory barriers that Black and other historically disenfranchised voters faced at the polls. However, the Voting Rights Act has been under attack in state legislatures and the courts, and most notably the U.S. Supreme Court in recent years. In his latest book, Antidemocratic, David Daley outlines the beginning of a movement within the legal system that helped pave the way for the Supreme Court to gut the Voting Rights Act in Shelby County v. Holder. David argues in his book that fringe theories about our elections threaten to undermine our democracy and silence voters. We'll be joined shortly by David to dive deeper into his analysis of this legal movement and to discuss what pro-democracy advocates can do today to protect the freedom to vote of all Americans. Before we start our discussion, I would like to go over a few housekeeping items. During the conversation, please use the comment section on LinkedIn or YouTube to submit your questions for members of the panel. At the end of the panel, we will start the question and answer section. We will do our best to answer every question, but in the interest of time, we may not be able to answer all of them. And if we're not able to answer all of them, your question today, and you're a member of the press, please email your questions to media@campaignlegal.org. If you are a member of the public and we are not able to answer your question, please email info@campaignlegal.org. Now I would like to take a moment to introduce today's guest, David Daley. Hi, David. David is the author of the national bestseller, Antidemocratic. He is also the author of another national bestseller that has been credited for helping kickstart the national drive to end gerrymandering. His journalism has appeared in the New Yorker, the Atlantic, the New York Times, and the Washington Post, among other publications. He is the former editor-in-chief of Salon.com and a senior fellow at Fairvote. He has taught journalism and political science as a visiting fellow at Wesleyan University, Boston College, Smith College, and the University of Georgia. Thank you, David, for joining us today. My first question is, when do you sleep?
These days, I think we are all not sleeping very often or very well.
Yes, I heard that. So your book tells the story of a modern legal movement that has led to the gutting of the Voting Rights Act. First, for those in our audience who are unfamiliar, can you explain what the Voting Rights Act is and why it's important?
Sure, absolutely. Thanks, first of all, for having me. I'm such a admirer and fan of Campaign Legal and so many of the brilliant people there who do such amazing, vital work for our democracy, from Trevor and Paul all the way down through Annabelle and Danielle and Jonathan and a million names I'm Blair and everybody I'm not mentioning. So thank you to Campaign Legal and all of you for the work that you do. This is the 60th anniversary year for the Voting Rights Act. We are rapidly approaching the 60th anniversary early next month of Bloody Sunday in Selma, Alabama, in which the national awareness of the necessity and urgency of the fight for the ballot really became absolutely unavoidable to Americans. I would say that the Voting Rights Act is the most important civil rights legislation in American history. That really what it did was it breathed life into the Reconstruction amendments, the 13th, 14th, and 15th Amendments to the Constitution that had in many ways been overrun by Jim Crow, oftentimes with the help and support of the U.S. Supreme Court. And really, what the Voting Rights Act did was it set out to truly enforce the 15th Amendment to the Constitution. 95 years after it was passed, and it enacted a national prohibition on the use of race and color to deny or abridge the right to vote. And this was a national prohibition, but it also set up a system called preclearance for those states and localities that had the worst history of abuse of the right to vote, and that those jurisdictions were effectively placed on a national probation. If they wanted to make any changes to their voting procedures, what they had to do was take them to the Department of Justice or to a neutral court in Washington, D.C. To have them approved first, because those communities had engaged in a form of stubborn resistance. There had been long concerted national efforts, whether the Civil Rights Act or, other attempts to get these communities to change their laws to stop the oftentimes brutal and always racially discriminatory voting practices and prohibitions that were taking place in these localities. But really, it took the Voting Rights Act in 1965 to bring change. And what we have seen since then really has been, almost since its passage, efforts to try and roll back that success. It started just a year later in the Katzenbach case, in which South Carolina said everything's fine here, and all states ought to be equal. How can you treat us differently? It took 50 years for that argument to finally hold sway at the U.S. Supreme Court, but ultimately, and I would argue, fortunately, it did.
Right. Well, that it's interesting because the 15th Amendment, purported to eliminate racial discrimination in voting, and of course, as we all know, it took 100 years, and that wasn't really a reality except for a brief time after Reconstruction. During Reconstruction, the Voting Rights Act, in a sense, was intended to make good on that promise of the 15th Amendment. Would you say that the pre-clearance provision that you talked about, that was a vital part of the success, at least during the initial 50 years of the success of the Voting Rights Act?
I would. I think preclearance really was the enforcement muscle of the Voting Rights Act. If you look at what had happened prior to preclearance, you take someplace like Dallas County in Alabama, where Selma is located. In 1961, you had about 1% of eligible Blacks in Dallas County who were actually registered to vote. By 1965, after 4 years of victories in court, trying to enforce the standards of the Civil Rights Act, that number had only risen to 5% because of the kind of stubborn resistance you would see. That local judges, who were themselves staunch segregationists, enforcing local prohibitions set up by segregationist sheriffs. What you would see would be a constant patchwork of laws designed to get around every other law. And so it took preclearance. It took the federal government saying, no, we have lost patience with that kind of resistance. And from here on out, you are going to have to run any change you want to make, not past a local judge, not past a local a sheriff, but this is a national priority, and we are going to fix this with a national solution. And those places that have stood in the way of equity and justice are going to be held to account.
Mm-hmm. And now you talk in the book that that even as the voting rights took effect and started to have, we started to see what one scholar has called quiet changes in the South and elsewhere, that you describe a legal movement that almost from the beginnings that ultimately culminated in the breakdown of the Voting Rights Act, or the effectiveness of the Voting Rights Act. How did the legal movement you described contribute to that breakdown? And maybe if you just kind of describe the movement itself.
Sure. What I really try to argue in Antidemocratic is that there has been a 50-year effort afoot by conservatives, by the right wing, really to use the courts as an instrument to blunt majoritarian power and to win political priorities and to enforce changes and advantages in elections that could not be achieved or won through the ballot box, for the very simple reason that most Americans disagree with these practices and procedures, and that you can trace this, back really to the opposition and the backlash to the Warren Court. You can trace it through the Lewis Powell memo in the early 1970s about the importance of the right in business trying to win political power through the judiciary. People can argue about the importance of the Powell memo, but it's not very often that one is a quiet Southern lawyer who writes a memo on this topic and 6 months later finds himself on the Supreme Court himself.
The late Justice Lewis Powell, right?
Yes, indeed. Who would then, in the 1970s, of course, be a part of a handful of campaign finance cases that would lead many years later to Citizens United. But certainly, what you see throughout the 1970s is the architecture of the conservative legal movement being built, the arrival on the scene of the Koch brothers and the Bradley Foundation and Scaife and Searle, and the role that all of these conservative funders would play in building organizations like the Heritage Foundation, like ALEC, like the Federalist Society over the years, that would turn into the makings of a conservative legal movement that has probably radically remade this nation in so many ways. I mean, now we have a U.S. Supreme Court with a conservative supermajority that has largely been appointed and approved by the leaders of that movement, by the Federalist Society, by Leonard Leo, by folks who have really set out to create the U.S. Supreme Court as the height of political power for the American right.
You say at one point in your book, and I'm not going to probably do it justice, but I don't have the quote in front of me, but I was going to ask you a little bit about the motivations behind that, and you say, well, when one seeks to describe this phenomenon that you're talking about, this coordinated effort to influence the judiciary in particular, that one might be called a conspiracy theorist, and that's not what you're doing. Can you talk a little bit more about that and what the what the motivations were. I mean, was it racism? Was it corporate power? Something else? A little bit of all?
Yeah, I think there's a little bit of all of that, but I think um, the fundamental goal here is to win political change through the judiciary that cannot be won at the ballot box. And I mean, I think if one is to look at where the nation is in 2025, 20 years after John Roberts came on the court, and really the process of ushering in this conservative supermajority began. When you look at where the nation is on voting rights, on guns, on abortion, on the regulatory state, on healthcare, on the environment, on so many of these topics, the court has been able to dramatically push the nation and the Constitution to the right in a manner that large majorities of Americans disagree with, but have been in many ways powerless to change. So I think that political power through the courts has really been the key motivation here. And when you then also dig down a layer and look at the kinds of decisions that this court has made on voting rights and democracy questions, whether you start there with Citizens United, move on to Shelby County, move on to Common Cause v. Rucho on redistricting, on Brnovich v. DNC, on Section 2 of the Voting Rights Act, all the way through some of the recent cases on presidential immunity, right? That you begin to see how so many of these cases and questions are really interlocking. Citizens United in many ways allows for dark money to step up in 2011 and contributes to the redistricting and gerrymandering epidemic that we see in the US House, but also in state legislatures around the country. So you begin to see state legislatures that are increasingly unaccountable to voters and packed by extremists. Those state legislatures, in turn, are then freed by the decision in Shelby County to go ahead and enact ever more stringent election restrictions. That all of this together, when you look at the influence of dark money, when you look at the influence of redistricting, when you look at the influence of removing preclearance, and then eviscerating really Section 2 and Section 5 of the Voting Rights Act, it all pulls together, I think, into a profoundly anti-democratic, and I say that with a small d, anti-democratic knot that is increasingly difficult for Americans to untie at all levels.
Well, I want to take a step back and ask you to, in particular, to kind of comment on or trace the history of Chief Justice John Roberts' influence even before he came on the court on voting rights and the impact. Maybe you can parse a little bit more. You've touched on some of the recent decisions, but how those decisions have impacted the ability to vote and have votes counted, particularly of Black and brown and other minority communities.
Yeah, Roberts is a fascinating figure, right? Because he has painted himself as a person who I would suggest he really is not. In the popular imagination, even I would suggest, in much of the popular press, Roberts is cast as a conservative, but a moderate conservative institutionalist, really most interested in the credibility of the court, and not necessarily as an ideologue. And one of the themes of this book is that while Roberts has worked assiduously to paint himself as a simple umpire, as a caller of balls and strikes, that metaphor that he's crafted so effectively has really disguised a much deeper and radical agenda and approach. And I think you can look back to Roberts' own boyhood as a start, right? I mean, Roberts, when he's before the Senate Judiciary Committee in 2005, he talked about his founding childhood memories being, of looking towards fields of corn and barns and silos of Indiana. You could almost Cougar Mellencamp song, right? Except that's not exactly how John Roberts grew up. John Roberts grew up in a town called Long Beach. Less of a corn farming community than it is really a lily white suburb of Chicago, waterfronts, ritzy environs, in which some of the wealthiest CEOs and business executives in Chicago go and live. Long Beach in 1965, at the time that the Voting Rights Act is passed, is one of the most segregated communities in America. Long Beach even advertised itself long after the nation passed anti-discrimination and housing laws as an all-white Caucasian Gentile community. So this is where John Roberts grows up. This is where John Roberts is educated. He goes from there on to Harvard and Harvard Law School, where he is in a position to be influenced by some of the new theories coming out of conservative thinking in the 1970s on the colorblind Constitution and how fighting racial discrimination is in effect its own form of racial discrimination. He becomes a clerk in William Rehnquist's chambers in the late 1970s, early 1980s, which in many ways was sort of a Federalist society before there was a Federalist society, and led by, lest we forget, a justice who, as it came up in his confirmation hearings, most likely personally took part in the suppression of the Latino vote in Arizona himself back in the late 1950s and the early 1960s. He goes on to the Reagan White House from there, and in late 1981, just before the reauthorization of the Voting Rights Act in 1982, young John Roberts from Long Beach, Indiana, who was playing lacrosse in lily white high schools at the time that, who was riding bikes to the local candy store at the time that John Lewis is being beaten on the bridge in Selma, is handed control of a portfolio of voting rights. And Roberts becomes one of the most crucial voices in the Reagan DOJ, who is working against really important changes that were attempting to be made to the VRA as it was being reauthorized in 1982. Roberts lost that fight in 1982 when the Voting Rights Act was indeed amended and reauthorized. But as he moved on to the courts, those fights, and I would suggest that radical lack of empathy or awareness really has stayed with him. And so we've seen case after case now, right, in which Roberts whether it's Shelby County, in which he simply decides that things have changed in the South and we don't need the protections of preclearance anymore, or the Common Cause versus Rucho decision, in which Robert says, well, a partisan gerrymandering is not a judicial issue. It's a political issue. You have to handle it through the political process, closing his eyes not only to modern statistical analysis that has been very clear as to when a partisan gerrymander goes too far, but to the basic problem here, which is that a partisan gerrymandering is not a political issue so much as it's a political problem, and that it can't be fixed through the political process, really. That's the entire point of why lines are drawn this way. The courts are really the only people who could step up and solve this problem in a neutral manner. And what I would say is that at every step in the way, in those cases and others, Roberts has put his thumb on the scale for the political party that put him and his colleagues on the bench.
It's interesting, your point about the kind of overlooking of the statistical analysis in these partisan gerrymandering cases. I mean, I once was an antitrust lawyer, and there are statistical methods that are used to determine whether, say, a merger is going to reduce competition, which are really, in some ways, quite speculative. Whereas voting, habit and predictions are actually can get pretty darn scientific. It's interesting that in that context, the court says, no, that's still too speculative. There's no way we can really know, how people will vote, and therefore, we can't adjudicate this because it's just too uncertain.
Sociological gobbledygook.
Yeah. You had an interesting experience that you describe in your book of actually going to former Justice Kennedy's house and after he had retired from the court and asking him if he had any regrets. Can you tell us a little bit about that?
I did, and it turns out that was the same morning that Justice Kavanaugh had a visitor at his house with a very different intention than mine. So I'm probably lucky that my visit turned out as harmlessly as it did. No, I mean, Justice Kennedy was one of the deciding votes in the Shelby County case, one of the deciding votes, certainly in Citizens United, one of the deciding votes, and had stepped down just before a Common Cause versus Rucho, but his unwillingness to find standing for the plaintiffs in Wisconsin in a case that I would suggest that the court could have taken care of the partisan gerrymandering problem right there before he retired and is replaced and a different court leads to the Rucho decision. But Kennedy, there seemed to me to be enough evidence that things had not changed in the South, right? I mean, Texas spent all of an hour before they enacted their new voter ID law, which the state themselves admitted would keep 600,000 Latino voters from voting simply because they knew that they lacked the specific forms of ID that the law now required. The kinds of laws we saw across in North Carolina and Florida. And
the state legislature said, now we can go with the full bill.
Now we can unleash the entire monster, right? And certainly we had seen the impact of redistricting. And so I wanted to ask Kennedy a simple question. Did you have any regrets? Do you have any sleepless nights like the rest of us? Except, boy, if I'd gone the other way on this, maybe things are a little bit different. And I walked up his driveway in suburban Virginia, knocked on the door, saw him at his kitchen sink washing up the breakfast dishes. He came over, opened the door, and I asked my question, introduced myself, and he barked, "No regrets. What would I possibly have to regret?" And before I could lay out, a handful of the things that I thought might be worthy of reconsideration, the door was closed up and chained and locked, and that was that. But I do think that these justices ought to have to answer questions. They don't really answer questions from the media. They don't really answer questions from the public. They may stand before a law school audience and take questions from another judge, right? But look at the Shelby County case, right, where Justice Roberts, the Chief Justice, essentially undoes the enforcement mechanism of the most important civil rights act in the nation's history, where he does so less than a decade after Congress had nearly unanimously reauthorized that act with a nearly 16,000 page report detailing all of the reasons why. And Roberts,
it was 98-2, I think, or
97-0, I think, in the Senate, and 390-25 or something like that in the House, right? Roberts does so by effectively making up his own theory of equal sovereignty amongst states. He does so by radically misinterpreting census data. And when Roberts is called out for the way he misinterpreted census data that actually would have led to the opposite of what he said it did in his decision, the court refused to answer any questions. They said that the justices don't take questions. Their decisions speak for themselves. And sometimes they speak for themselves with serious errors. And sometimes a decision like Shelby County, in which Roberts creates his own standard of equal sovereignty among states, which he creates out of whole cloth that he had, dropped Hansel and Gretel style from the Northwest Austin case a couple of years before in his own dicta there. And he quotes himself, and he takes the precedent from Katzenbach and he simply edits out with an ellipsis the part that he doesn't like. It does seem as if maybe there ought to be some ability to question folks about this.
Well, and that raises another interesting point that you discuss in the book, and particularly in the concluding part where you talk about the kind of the anti-democratic nature of the court and lack of democratic accountability. Which reform ideas do you think have the most promise of reversing our current trajectory, and how do pro-democracy advocates go about rallying enough public support to get those changes in place?
Yeah, it's a great question. I think we can start with the reform ideas that are already at 75% amongst all Americans, not just Democrats, not independents. Democrats, independents, and Republicans. You can find a nearly 75% support for the idea of judicial term limits. You can find nearly 3/4 support for the idea of a judicial ethics code, a real binding ethics code that has, real teeth to it. And I think you could begin a lot of the process of restoring the credibility that this court has taken upon itself to dismiss and lose through their own actions, through the gifts and the travel that they accept from the same conservative plutocrats that are funding the organizations that helped place them on the bench and fund the movement in general and the cases that are being put before them. I also think we need to be talking about a larger court. We could do that simply, the number 9 is not set by the Constitution. It could be adjusted. It does not have to be adjusted for political purposes. It could be adjusted in any number of ways. You could imagine a U.S. Supreme Court that worked much like lower federal courts, right? In which a panel of judges was picked, in a neutral fashion to go ahead and hear a case. You could imagine laws that Congress could pass to limit the jurisdiction of the courts on certain topics. But the consequences for not doing this, I think, are going to be really apparent to us all. There's going to be, increasing use of things like unitary executive theories and major questions doctrines, all of which sound legal but are really dressed up constitutional approaches to trying to jerry-rig the outcomes that a handful of people would specifically like to see. And I would suggest that oftentimes what we're getting, right, is that the same organizations that find the litigants and begin the process of litigation and then fund the legal bills for those cases, that also support the law schools and the professors that generate some of the scholarship and the theories that fill the amicus briefs that the same organizations pay for, and then try to place these cases before ambitious judges that have been trained and handpicked and kept in ideological line by some of these same organizations. That what we really need is a lot more transparency around the court, and a lot more politicians, I think, and leaders who are willing to come out and call this what it is. I use at the beginning of Antidemocratic the 2 quotes that start the book, and I'll end right there. Abraham Lincoln, from his first inaugural in March of 1861, the candid citizen must confess that if the policy of government upon the vital questions affecting the whole people is to be irrevocably fixed by the decisions of the Supreme Court, the people will have ceased to be their own rulers. And then John Roberts on C-SPAN, just before the Citizens United case is handed down, the most important thing for the public to understand is that we're not a political branch of government. They do not elect us. If they do not like what we are doing, it's more or less just too bad. And I would suggest that in a democracy, or in a republic, or in whatever it is you would like to call it, the idea that 9 unelected people can say that if we do not like what they are doing, it is just too bad, is wholly unacceptable. And it is time for us all to be saying that very clearly.
Interesting. Let me just challenge you a little bit, and then we're going to go to some audience questions. But during the civil rights movement, even before with the Brown versus Board of Education, during the height of the Warren Court, some might argue that, thank goodness, it was somewhat contra-majoritarian court, willing to have the courage to kind of step up to the tyranny of the majority. What's your, you have a comment on that, or what's your view on that?
No, I think that's a really important point. Certainly, the Warren Court was brave. Was the Warren Court contra-majoritarian? I'm not certain it was. I mean, I would look at the apportionment revolution that the Warren Court ushered in. The fact that many states across the nation in their state legislature and their congressional districts were wildly uneven by magnitudes of thousands in some of these state districts. I'm not, I'm not aware of any public opinion polling on some of those cases, but my sense would be that a majority of Americans would have fundamentally supported the constitutional rights of one person, one vote. That it simply took the Warren Court to, step in and to enforce a national standard, to step in and enforce the Constitution. To me, I think that there's, a criticism that is sometimes made of people who criticize the court and suggest, well, you just don't like the decision that the court made, and your problem is not with the court, but with the decision. And what I would say is that the Reconstruction amendments to the Constitution, to me, are the animating spirit of what American democracy means. That in some ways, the Reconstruction amendments, to me, ought to be considered the founding documents of this nation, that they take what was said in the Declaration and the Constitution and they apply it to everybody in a way that those initial documents do not. And when I talk about the court being an anti-democratic court, what I mean is that there have been two long-standing movements in American life, and one of them is the ability to attempt to animate and breathe life into those amendments and to create a multiracial democracy. And the other is an attempt to block that, and that the 13th, 14th, and 15th Amendments to the Constitution were met by the U.S. Supreme Court in the Civil Rights Act cases, in the Katzenbach cases, the Cruikshank cases, with decisions that directly undermined the animating spirit of those amendments. And it took the Voting Rights Act to roll that back and to reanimate those amendments. And it did not take long for the forces of retrenchment to try and block what happened with the Voting Rights Act, right? I mean, Katzenbach is filed in September 1965, a month after the Voting Rights Act. So we're coming up on the 60th anniversary of the opposition to the Voting Rights Act as well. And that these are the two spirits in American life. One that leads towards a genuine multiracial democracy, and one that leads backwards. I make no bones about where I stand in that fight.
So we got a question from the audience, and I believe the context is what you've talked about in terms of the cutbacks and of the Voting Rights Act. Given or considering the difficulties that you've talked about, what are the ways that people can support changes to the current context in terms of perhaps restoring some of those protections?
Yeah, I think it's a political question, right? I mean, I think we have to begin the process of really talking about the connection between the kind of country we want to live in, the kind of country in which majorities rule and consensus can still be found on issues of public importance, and where we stand right now, which is often a case of gerrymandered legislatures passing laws that members of that state disagree with. I mean, you can look at the abortion decision, right? In which Justice Alito says, "Well, I'm not overturning Roe versus Wade so much as I am taking a question of public importance and returning it to the people and their elected representatives." Well, what we know full well, and what Justice Alito knows full well, because he was one of the votes in Common Cause versus Rucho that made it impossible for citizens to challenge partisan gerrymandering in the federal courts, is that it's not exactly the people and their elected representatives. It's the people and representatives who've been elected from districts essentially set up to be completely uncompetitive. And so I think we need to make really clear the connection between political reform, judicial reform, and the kind of decisions that we are getting. That it's not coincidence, it's not accident, but all of this is deeply intertwined, and we don't fix it until we get to the very nub of it.
And with regard to partisan gerrymandering, which you spoke of in your answer, that's one of these things that legislatures often do, but people don't really like, do they?
No. I mean, I think one thing we can all agree on: red states, blue states, purple states, we all hate gerrymandering. Everybody hates the idea that politicians can draw their own districts, choose their own voters, and effectively, the power of partisan gerrymandering is the ability to create a non-competitive district that one party or the other can hold for the next decade. We should be electing members of the House, members of state legislatures every 2 years, right? Not every 10 years when we redistrict. And gerrymandering effectively insulates the people and their representatives, and it makes it more difficult for majorities to throw the rascals out when they so desire.
I think we may have another question from the audience, but here it is. The president has been engaged in some very anti-democratic activities since assuming office. How confident are you that the courts will serve as a check on his actions?
It's a great question. I mean, I think what we have to keep using the courts. We have to keep fighting. It's what we do. It's what amazing organizations like Campaign Legal do. And so this litigation will go on. There's been, an absolute torrent of it over the course of these last few weeks. And I'm very grateful to all of the organizations and attorneys who are working on those important cases. I think it remains to be seen what the outcome of it all will be. And I think that's for a handful of reasons. The first is that so many of these judges are on the bench for political purposes, that the Supreme Court has been wired over this time to have folks there who are more likely to rule in a certain way. The second is just the absolute speed of what has been coming, so that there has been so much change coming from this administration, and it's been coming so quickly on so many fronts that courts move slowly oftentimes. Can courts address the speed of this change in effective manners? When you look at something like, for example, USAID, courts have said, well, you have to go ahead and unfreeze some of that money, right? But will so much be broken beforehand that it renders even a victory a hollow one? I think is an important question. And then I think that the third front is that we still don't know is whether this administration will listen to the courts if they step up and stop him. I think we've already seen some really disturbing willingnesses on behalf of this administration not to listen to some of the decisions that have already gone against it. And we've heard, I think, some really disturbing statements from the vice president and others on whether they would even have to observe these decisions, right? And I think even the president himself has been talking about how if he behaves in a way that he believes is good for his country, he is not breaking any laws. Indeed, unfortunately, this court gave him an awful lot of immunity to be breaking those laws in acts that are deemed official acts, right? So there's a lot we don't know. There's a lot of important work underway, and very grateful to all who are doing it.
Well, thank you. I think we have one more question from the audience, and then I'll probably ask you for some final thoughts, David. Do you see proportional representation as viable, necessary reform to address partisan gerrymandering and improve voter turnout, and even to reduce polarization?
Yes, it's a great question. And I mean, I think we have to think about political reforms and judicial reforms at the same time, right? I mean, in many ways, I think the real solution to partisan gerrymandering is doing away with the idea of single-member districts and the importance of those district lines in the first place. If you were to, I mean, I live in Massachusetts, and Massachusetts has 9 members of Congress, and they're all Democrats. And there's plenty of Republicans here, and they've got no representation in Congress at all. And if you look at, Tennessee or some other states which are pretty similar, it's pretty much the other way around. And I do think that if we use multi-member districts, if we elected through a more proportional system, you would see more need for consensus in our politics, that you would put an end to single member districts rigged for one side that are effectively determined in a primary by 34% of voters, and you end up with caucuses and more extreme members. So I think that there's a lot that we could do with ranked choice voting, with things like the Fair Representation Act, with the kinds of more proportional systems that I think have been gaining a lot of momentum lately, have a lot of promise.
Yeah, that's something we have. The ranked choice voting is something that we at CLC have worked very hard to promote and support.
Yes.
Well, David, I know there's so much in the book, and so we unfortunately we don't have enough time to talk about it all. I could have this conversation all day long, but just want to give you an opportunity for any closing thoughts. I encourage people in the audience to go and read the book. It's an excellent book. David, if you want to leave us with some closing thoughts.
Sure. I think that this is an extremely powerful and fraught moment, and that the courage that it takes to be in these fights is absolutely everything. So I'm just so appreciative to Campaign Legal and to so many of the other organizations that have been active and involved in the battle to protect our democracy. It will be 60 years since the passage of the Voting Rights Act. We're coming up next month on 60 years since That's in Selma. And what I think is so important to understand is that the words of Ruth Bader Ginsburg in the dissent in Shelby County, I think, still really ring true when she talks about you don't throw away your umbrella in a rainstorm because you're not getting wet. And the Chief Justice believed that the nation had so fundamentally changed that we could toss the umbrella aside. It didn't take long for all of those localities that had been protected by preclearance to get drenched. And we're still in the midst of the same fight for equality and multiracial democracy that we always have been. And our fight is not more difficult than the fight that John Lewis and all of those brave foot soldiers on that bridge in Selma 60 years ago engaged in. And they were victorious. They changed the nation. They pricked the nation's consciousness, and they brought about change. And that same spirit, that same fight is what it's going to take to bring about change now. They won under much tougher circumstances than we all face. So let's have that stiffen all of our spines and get us ready for the battles ahead that can and will and must be won.
Well, thank you so much, David. Those are inspiring words. And, thank you for writing the book. It's such a well-researched, analyzed, and argued book. The book is Antidemocratic by David Daley. I encourage everybody to get the book and to read it. And appreciate your time with us today, David. For our audience members, if you have additional questions or would like more information, please email us at info@campaignlegalcenter.org. Thank you again, David, and please enjoy the rest of the day, everybody.